Yay, oh yay, oh yay. The Honorable Court of Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning, and welcome to the Court of Appeals. Appreciate you being here this morning. We will get started very shortly, but before we start, I have a few introductory remarks to make. First of all, even though I know we've got experienced practitioners, I would like to take time just to explain preliminarily how things are done here. First of all, as far as the argument, each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, the proper procedure for that is to request it after you've introduced yourself, but before you begin your oral argument. You may reserve up to 5 minutes of rebuttal time. Appellee gets no rebuttal time. Our lighting system on the podium, I believe, is very straightforward. We have 3 lights, green, yellow, and red. Once you begin your argument, the green light comes on, and as long as the light's green, you got plenty of time. Once the light turns yellow, it means you're running out of time, and once the light turns red, you are out of time. So we ask that you please respect those time constraints. One other thing that I want to make sure everybody understands is these oral arguments are being live streamed. So think about what you're saying when you're saying it, because we have sometimes had people say things they wish they had not have said because it's going out to everybody when you say it. So just keep that in mind, please. Finally, I want to introduce your panel for this morning. Judge Kenny Armstrong from Memphis, Judge Carmen McGee from Savannah, and I'm Steve Stafford from Dyersburg. Miss Angie, anything we need to take up before we call the first case?
No, Your Honor.
All right, you may call the case, please.
Willie Graves versus Irelia Calloway et al.
All right, sir, we will hear from the appellant.
Give me honest. My name is James King. I am from Memphis. I would like to reserve 3 minutes as rebuttal.
All right, sir.
I'm sure the court has read the briefs that were submitted to the court.
That would be accurate.
and typically, Your Honor, I don't like to, rehash the facts, but I think a slight regurgitation of the procedural history is important because it gets directly to the point that I need to make here to properly represent my client. This case was filed in September 2019. An answer was filed October 21, 2019. 3 days later, a motion for summary judgment was filed by the defendant, and I think it was October 24th, 2019. A notice was filed to have the motion for summary judgment heard in November. Motion for summary judgment was heard on December 6th. Prior to the motion for summary judgment being heard, my office reached out to opposing counsel and attempted to get him to agree to allow the plaintiff to take a deposition. I understand that we could have noticed the deposition. Our office did not do that because collegiality. We always try to get a date that's sufficient with the opposing counsel to take a deposition. We couldn't get that done. We then asked that he move the motion for summary judgment to allow discovery to be had. Would not agree to do that as well. The day before the motion for summary judgment was heard, my office filed a notice pursuant to Rule 56.07 to have the court allow the plaintiff to engage in discovery prior to the court ruling on the motion for summary judgment. That same day, we filed a motion for leave to amend the complaint. out of an abundance of caution, to more specifically set forth the allegations in the complaint and to clarify certain allegations based upon the affidavit filed by Ms. Calloway. Surprisingly, the lower court denied the motion for summary judgment, granted the motion for summary judgment, denied the Rule 56.07 application to engage in discovery without explanation, and then told the parties to come back. She would reserve ruling on the motion for leave to amend and come back in January, and that's what happened. I have reviewed the law in Tennessee, in most every other jurisdiction, and I have not found a single case that has allowed a motion for summary judgment to be granted prior to the parties engaging in discovery. I've not found that. I don't think that, and I've been practicing law for 20 some odd years, federal court, state court, been up to the Sixth Circuit Court of Appeals, I've argued cases up there, and I have never had a court grant a motion for summary judgment without engaging in discovery. This matter had only been pending for a period of 3 months since he had filed 2 months since he had filed an answer. And if you practice in Memphis, Judge Armstrong, I know you know the ropes in Memphis. Typically, when you ask for discovery, you get a call back from the opposing counsel saying, "Hey, can I get an additional 30 days?" And after you get an additional 30 days, then they'll say, "Well, if you just file a motion, we'll consent to it and give me 30 days." Discovery is, there's no way you can get discovery done in Memphis or in any jurisdiction in 30 days. You just can't do it. The court should have allowed the parties to engage in discovery prior to ruling on a motion for summary judgment. Rule 56 in and of itself talks about answers to interrogatories, talks about evidence. It contemplates allowing a party to engage in some semblance of discovery in order for the court to determine if there's a legitimate issue as to a material fact. We cannot allow courts to grant motions for summary judgment without respecting the rules of civil procedure. I think there was no discovery in this case at all. And by affidavit just saying, "Your Honor, we haven't taken discovery," and the judge denies that request, is a problem. It's a problem. It's a legal problem. It's one that I personally have never, ever, ever seen happen after 2.5 months of a case being filed, or 3 months after a case being filed and answered. And the judge, the lower court judge, reserved ruling on the motion for summary judgment and said she would come back and maybe allow the amendment and then overrule herself. However, when we go back in January, she said we need additional briefing on the issue because I don't know now whether or not I can actually go back and review my order without filing a Rule 60 motion. Well, the lawyer who was handling it came back to the office. He was a little bit perplexed with respect to that. And I said, well, it's the law of the case. This is her court. She controls her docket. We got to do what she says we got to do. And that's what he attempted to do. Nonetheless, the court, there was no finality language in the order granting summary judgment. It was an interlocutory order. The court could have on its own, sua sponte, reverse herself. She could have allowed the motion for leave to amend to be had in January 2020. She didn't do it. And she required them to file motions and briefs pursuant to Rule 60, and we went off on this road of procedural. It's a procedural mess, quite frankly. The court could have easily allowed, the right thing to do would have been to deny the motion for summary judgment in the first instance and allow the parties to proceed in discovery before ruling on the motion for summary judgment.
Did you, I assume you filed an affidavit in support?
Correct.
Did you outline in the affidavit the discovery that you wanted to take?
We wanted to take discovery in the affidavit. That's what was outlined in the affidavit.
What does that mean?
That means that a party should be able to take discovery prior to ruling on the motion for summary judgment. I think in the affidavit, he did mention something to the effect that he would like to engage in discovery to determine what was going on with respect to Ms. Calloway not being at the home, I think, on the date in question. But be that as it may, Your Honor, I don't think any one of the judges up here would have even granted a motion for summary judgment, would have on its own probably sent the parties out to take discovery without even the filing of a motion or affidavit pursuant to Rule 56.07, because the parties are allowed to engage in discovery prior to a motion for summary judgment being filed in the first instance.
In that request for discovery, did you outline what you expected discovery to reveal that would assist you in any way in defending against a motion for summary judgment? You know, keeping in mind this is a case where your plaintiff fell off a ladder. What did you expect to uncover if the court had allowed the discovery before ruling on the motion for summary judgment? And I agree with you. Typically, you don't see a grant of a summary judgment without allowing discovery. But in this case, based on the facts, would the discovery have been futile, really, in defending against a summary judgment motion?
I don't see how it would have been futile, Your Honor, because I think in reviewing the case last night before I came up here, and reviewing the affidavit and reviewing what was requested, we were so early on in the case that by filing an affidavit, as she did, and without being able to sit down and take a discovery deposition in the first instance, to know exactly what you're gonna get in discovery at that point is kinda it's kinda hard to determine. So to allow us to take a deposition to figure out what we need to do to prove our case in the first instance it was vital. But the discovery that we would have needed would have to be whether or not Ms. Irelia Calloway was on the property at or about the time, which I think the affidavit says she wasn't. Whether or not the claim that we were asserting against Irelia Calloway was one that may have been her daughter. I'm not so sure if we got the right name of the proper defendant now after reviewing this. So to seek discovery, to find out who the person was, if it's a misnomer, we could have amended the complaint on the misnomer and proceeded forward. I think it was her daughter. I don't know if her daughter's name is Irelia Calloway or what, I don't know. But the point I'm making is, without engaging in discovery to figure it out in the first instance, it's very difficult to figure out what you need when you haven't taken any, and I repeat, any discovery.
Why did you file a motion to amend then?
Well, the motion to amend was filed based upon the fact that the affidavit set forth that Ms. Irelia Calloway wasn't at home. And so if she wasn't at home and she had reached out to my client and said, hey, I need you to come to the home to repair whatever the work he was gonna do in the ceiling, she should have given him some sort of warning that, hey, there's rusty nails in my attic, you gotta be careful.
So you filed the motion to amend based upon what was contained in the summary judgment motion?
In the affidavit.
In the affidavit, okay. Did the trial court ever rule on the motion to amend?
I don't think there's a formal ruling on a motion for leave to amend, but there was a denial of the Rule 60 motion, which was kind of based on the motion to amend. And her holding was that it was dilatory due to the fact that a year and a half had passed since the filing, and we had gone through COVID. There was a lot of things going on in the court, and a year and a half had passed since the.
Does that create a final judgment problem if there's no order on the motion to amend?
Well, the order on the motion to amend we're here on the, I think we're here on both issues. If there's no order on the motion for leave to amend, then I would imagine that the court, that this court may not even have jurisdiction, possibly.
That's the question.
On the issue, on the motion for leave to amend, and that would have to go back to the trial court in the first instance. But secondarily, the motion for summary judgment that was granted is why we're here. Now, that's the one where there's a final order that's entered, and I would submit to the court, once again, that there's just no way to, I don't think, a way that a court could grant a motion for summary judgment without allowing a party to engage in discovery in the first instance. Not after 2 months.
You've used your time. Thank you.
Thank you.
You've got your rebuttal time.
It's had 46 seconds, that's why I thought I'd.
Going the other way.
Oh.
Good morning.
Morning.
My name is James Horner. I represent the defendant, Irelia Calloway. First of all, before I get into my argument, I think it needs to be pointed out that this is not a factually difficult case. Basically, the plaintiff alleged in their original complaint that my client is the owner of the home wherein he was present for purposes of placing a squirrel cage in an attic above her garage. The allegations of the complaint as to my client were simply that she was present, she was conversing with the plaintiff's helper who was holding a ladder, and that based upon that conversation, she distracted the helper, causing the helper to lose control of the ladder, causing the plaintiff to fall from the ladder and lacerate his left arm.
That's the original complaint.
That's the original complaint. Now, Rule 56 says that a motion for summary judgment can be filed at any time after the filing of the complaint by the defendant. In this particular situation, that's what we did. We filed an answer first, denying liability and asserting a number of affirmative defenses, including the lack of breach of any duty by my client. We then filed a summary judgment based solely upon my client's affidavit, which stated affirmatively that I was not present, I was not conversing with the gentleman holding the ladder, I did not do the things that I've been accused of in the plaintiff's complaint. I was not present, I was at church. That was the sole basis of our motion for summary judgment. Was not there, could not have done what we've been accused of. And that motion was filed approximately a month and a half before the motion was set for hearing on December the 6th. In that period of time, the plaintiff filed no discovery. If discovery would have been filed, it would have been due before the date of the hearing. Filed no request for production of documents, noticed no depositions, filed no response to the motion, the substantive arguments made in the motion, and filed no response to our Rule 56.02 Statement of Undisputed Facts.
Was there a request made to take your client's deposition?
There were communications between me and Mr. King's associate. I advised Mr. King's associate that this wasn't a case that a deposition was needed based upon the fact that our affidavit simply said that we were not present.
That assumes that everything stated in the affidavit is true, and that's why you have discovery, and you can then challenge that.
Well, this goes back to Your Honor's question about whether or not the deposition would have been futile. It would have been. The only issue was my client present? Now, Mr. Graves, the plaintiff, was present. He was there. He knew who was there. He was in control of all of the operative facts that were needed to respond to this motion for summary judgment.
And then in the complaint, did he allege that your client was there?
He did. And that my client was the individual that communicated with the gentleman holding the ladder that caused him to lose control of it. So he was present, he was there, he was at the scene, he knew who was there, he alleged my client was there. If he disputed the sole allegation in my client's affidavit that she wasn't there, all he had to do was file his own affidavit with one sentence saying she was there.
Isn't that essentially what he did by filing a motion to amend the complaint?
With all due respect, a motion to amend is not a response to a motion for summary judgment.
I'm well aware of
He-
that, but doesn't a motion to amend take precedence over a motion for summary judgment?
I don't think it does, Your Honor. I think he has to, when faced with a properly supported motion for summary judgment, he has to come forward with proof to create a disputed fact. And a motion to amend
Let's
is
look at
not
the
a,
situation that existed, as I understand it, and you correct me if I'm wrong. You have pending before the court a motion for summary judgment on the original complaint. But before the motion for summary judgment's heard, you have a motion to amend that's filed that changes significantly, I would assume, since we're talking about who was there and who wasn't, changes the allegations in the complaint, at least as to a party. So would it not be more expedient from a judicial point of view to take up the motion to amend first?
well, I think based upon the fact that the motion to amend was only filed hours before the hearing was set on the motion for summary judgment, and that it wasn't noticed for hearing and was not before the court only had in front of it my properly supported motion for summary judgment with no response having been filed to that.
But it was in the record, wasn't it?
It was filed the afternoon before, so yes, it was in the record. But at the same time, that's not a proper response to the motion for summary judgment. That's why I think the court said that if you properly prosecuted a motion to amend, then we would go back and reconsider where we were on the motion for summary judgment. And at that point in time, I think the plaintiff,
There's no question the order granting summary judgment was interlocutory at that point in time.
that's correct. There was no Rule 54 finality language in the order granting the motion for summary judgment. But at that point in time, in order to grant a motion to amend after an order of dismissal with prejudice had been entered, the plaintiff had to take certain procedural steps to have that motion, that order set aside. Until that order was set aside, there was no complaint to amend. And there are several Tennessee cases that I cited in my brief, including the state volunteer case, which is clear on that. Once an order of dismissal has been entered, in order for the court to grant a motion to amend, that order has to be set aside either under Rule 59 or Rule 60. And in this particular situation, the plaintiff could have sought to revise the order under Rule 54.02 because it was not a final order, or could have filed a Rule 59 motion to alter or amend. But instead, what plaintiff did was file a Rule 60.025 motion to attempt to set aside the order. And the courts that have addressed Rule 60.025 motions have routinely found that 025 is not to be used to relieve a party from a deliberate decision that he made in the prosecution of a case. I think it was in the Bradley case cited in my brief where a employee plaintiff had filed suit against a defendant employer. The defendant employer filed a motion to dismiss or summary judgment, I forget which one, based upon the exclusive remedy provision of the Workers' Compensation Act. The attorney for the plaintiff did not oppose that motion. The motion was granted. The plaintiff then found another attorney who sought to set aside the order granting the dismissal based upon Rule 60.025. And the court found that that was not a proper means or use of Rule 60.025 to correct a situation where a party or a party's attorney had made a deliberate decision with how to prosecute the case. In this case, we have a similar situation where plaintiff's attorney, when faced with a properly supported motion for summary judgment, did not file a response to it, did not file a response to the statement of undisputed facts, did not file an affidavit opposing the simple affidavit of my client that said she wasn't there, and didn't file any discovery. Waited until hours before the hearing and filed a motion to seek discovery and to amend the complaint. Now, with respect to the motion to seek additional discovery under Rule 56.07, if you look at the affidavit itself, it basically says that we were unable to conduct discovery because our schedules were too busy. That's the excuse used in the affidavit to request additional time. And in my opinion, I found no case that addressed that particular excuse, but an attorney, especially when you have two attorneys of record, indicating that the reason that they didn't respond or that they needed more time to respond for discovery was that they were too busy is not a sufficient basis.
Let me ask you, have you found a case where the request was made for discovery in connection with summary judgment motion, and the trial court denied the request of discovery, and the Court of Appeals, or any court for that matter, found that that was not an abuse of discretion? I mean, I've had your firm here a number of times before me requesting that we set aside a reverse motion, a vacate a motion for summary judgment because discovery wasn't allowed. What is the basis for the trial court to not allow discovery? I mean, it's provided for in the rules.
Well, I think the standard of review is an abuse of discretion. And I think that when you look at this particular case, with the fact that the motion for summary judgment had been pending for a month and a half, with no steps taken to have conducted discovery, on a simple motion that could have been refuted by a simple affidavit that said she was present, that the discovery that was sought would have been futile.
Is there some simple motion exception in Rule 56?
There is not, Your Honor. I think each motion for summary judgment stands on its own. And the court has to view that motion for summary judgment based upon the complaint, whether there's a disputed fact. And in this particular situation, the essential element of the breach of duty by the defendant was negated by her simple affidavit that said, I was not there. And when you look at the status of that motion, when it was heard by the court was proper in granting it based upon the record before the court. And again, there was no response to the statement of undisputed facts or any substantive response to the motion. Basically, they just...
Let me take you to the motion to alter or amend. Apparently, the trial court found that the motion to alter or amend denied the motion to alter or amend because of undue delay and futility. Seemingly some prejudice. So what's the proof of prejudice other than the passage of time in this matter?
Well, the court never actually entered an order on any motion to amend. The only...
We have a final judgment.
Yeah, you have a final judgment based upon the Rule 54 certification. But
if we still have an order out there on this, does that... I don't know that Rule 54 trumps that. It may. I have no idea.
Well, the order that was appealed is the order granting the motion for summary judgment and the order denying the Rule 60.02 motion.
So you're saying the motion to amend has nothing to do with what's in front of the court today?
I think the court inferentially denied the motion to amend when she denied the Rule 60.025 motion.
Is there an order in the file to that effect?
There is not.
Okay. Well, let's go back to the prejudice here. Can the court infer prejudice?
I think under the circumstances where the motion was out there for a year and a half, and along with prejudice, the court also addressed the futility of the motion to amend in her order. And I think those two go side by side.
But the futility was directed at the original complaint as opposed to the amendment. And the complaint never was amended, but there was a motion to amend the complaint.
I think the futility was also addressed to the motion to amend. And if you look at the,
How can the court determine whether the motion to amend is futile if it never heard any evidence or or allowed the parties to conduct any discovery as to the amended complaint?
well, the court did hear arguments on the motion to amend. And as part of that argument, as set forth in our brief, is our argument that the motion to amend would have been futile because the allegations in the proposed amended complaint would have been barred by the statute of limitations. And that's based upon our position that plaintiff attempted to assert a totally new cause of action in their proposed amended complaint, not based upon my client's negligence in interfering with the holding of the ladder, but a premises liability claim based upon the condition of nails in the attic and a slippery floor in the garage. Neither one of those allegations or no premises liability claim was asserted in the original complaint. It was simply a negligence claim.
That would have been an excellent legal question for the court to consider.
Well, I think that's part of her futility ruling in her order, because those issues were addressed and argued on the motion to amend.
But the only evidence in the record, I believe, as Judge Armstrong has pointed out, is whatever affidavit you filed, right? On the original summary judgment hearing.
Yes, that's the only
evidence the court has.
That's the only sworn evidence in the record that was unopposed.
A lot of decisions were made with no evidence.
The critical evidence was the affidavit. It negated an essential element of their claim, that they had an obligation under Rule 56 to come in and present evidence to show that there was a genuine issue of material fact for trial, i.e. she was there.
Understand? Thank you.
Thank you, Your Honor.
Well, if you've got, what'd you say, 3 minutes?
3 minutes, Your Honor.
Okay.
One of the reasons why discovery would have been very helpful in this case is because the defendant would have found out that Mr. Graves didn't know Irelia Calloway. He didn't know, in fact, the only person who knew that was the guy holding a ladder, so he didn't know anybody's name. So if Irelia Calloway files an affidavit saying that she wasn't there, then all we can do with the amended complaint is say, okay, well, here's what should have happened. He didn't know her. He hurt his hand, he went to the hospital, and that's what happened.
Let me ask you just a real simple question. What prevented you from doing discovery here?
Okay, at the time, I had a federal court case. It was against Memphis.
Well, wait a minute. Let me rephrase my real simple question. What evidence is in the record that prevented you from conducting discovery that the court could have considered?
The affidavit that was filed by Mr. Linquester. The affidavit just clearly says, Your Honor, that the motion for summary judgment was just premature. There's a requirement under the law that premature motions for summary judgment can't go forward.
There's nothing that says you can't file a motion for summary judgment as the defendants filed.
Correct, but a motion for summary judgment has to be based upon evidence that's before the court.
And they submitted their evidence.
Of course they did, but the other side didn't get an opportunity to. And I cited a Supreme Court case that referenced another the U.S. Supreme Court case. It talked about the very thing about Rule 56F and the fact that you cannot have a summary judgment motion that's premature. And if a party files an affidavit setting forth, and in our case, our affidavit is that we haven't taken any discovery. And then on that basis, Your Honor, I think that the court...
But we come back to my question of, you had the right to take discovery, notice depositions, submit interrogatories, request to admit. You didn't need the court's approval for any of that. Correct,
Your Honor, but there is no way in a month and a half that a party can take discovery and do all these things when another lawyer is preparing for a trial in federal court. That's what was going on. That goes part to my argument with respect to collegiality in the practice of law. Years ago, it would have been no issue. Lawyers would have understood that. You heard the opposing counsel say, we didn't think there was a basis to do it because all it was said here was that she was not there. So we don't get a chance to take it. a deposition?
He doesn't get to decide, does he?
He does not, Your Honor. I guess Your Honor is right. We could have filed a notice and notice it up, and whether or not she shows up is another motion for the court. But that's back to my point about collegiality in the practice of law. Where is it?
Understand, I appreciate collegiality, always have. Thank you, sir, you've used your time.
Thank you.
Gentlemen, we appreciate your arguments. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. You may be excused.